It's the content creator with force like Darth Vader. One path is the way that I'm taking, getting closer to God in a tight situation. Back on the track with the facts and all that. This is part two of the name game titled The Game of the Name. So without further ado, here is part two. Applying it all to current laws. Title 3, Pleadings and Motions. Rule 9A, Capacity. Federal Rules of Civil Procedure states in part, when an issue is raised as to the legal existence of a named party or the party's capacity to be sued or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars, bold emphasis added. At this juncture, it is clear that the existence of a name written in all caps is a necessity created entity. This is surely an issue to be raised, and the supporting particulars are outlined within this article. Use of the proper name must be insisted upon as a matter of abatement, correction, for all parties of an action of purported law. However, the current courts cannot correct this since they are all based on presumed, assumed, fictional law and must use artificial, juristic names. Instead, they expect the lawful Christian man or woman to accept the all caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce will be exposed and a worldwide plunder enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, they will be required to succeed in life by honest, productive labors, the way those upon whom they parasitically feed are forced to conduct their lives. Oklahoma statutes. Since the entire game functions on the basis of people's failure to properly rebut a rebuttable presumption, the issue then becomes how to properly rebut their presumption that you are knowingly, intentionally, and voluntarily agreeing to be treated as if you were the all caps name. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in Oklahoma Statutes, Chapter 22, subsection 403. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceedings his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information. American jurisprudence. In general, it is essential to identify parties to a court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how. If not properly identified, all corresponding judgments are void, as outlined in 46 American jurisprudence. Second, at judgment. Subsection 100, parties. A judgment should identify the parties for and whom against it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the persons for and against whom the judgment is rendered. Technical deficiencies in the naming of the persons for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of that party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnote numbers and sites are omitted. The current scene in America. Legal person. One of the terms used predominantly by the present civil governments and courts in America is legal person. Just what is a legal person? Some definitions are a legal person, a body of persons or an entity as a corporation considered as having many of the rights and responsibilities of a natural person, and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Person. 1. A human being, a natural person. 2. A corporation, an artificial person. Corporations are treated as persons in many legal situations, although the word person includes corporations in most definitions in this dictionary. 3. Any other being entitled to sue as a legal entity, a government, an association, a group of trustees, etc. 4. The plural of person is persons, not people. See that word. Orange Dictionary of Law, West Group, 1999. Person, an entity with legal rights and existence, including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court either by themselves or by a lawyer, and generally other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are minors or under some kind of other incapacity, such as a court finding of mental incapacity. Many laws give certain powers to persons, which in almost all instances includes business organizations that have been formally registered, such as partnerships, corporations, or associations. Duhame's Law Dictionary. Person, noun, Latin persona, said to be compounded of per, through or by, and sonus, sound, a Latin word signifying primarily a mass used by actors on the stage. Webster's 1828 Dictionary. A corporation incorporated under de jure law, in other words, by bona fide express contract between real beings capable of contracting, a phenomenon that went extinct almost 70 years ago, is a legal fact. Using the self-styled juristic artifice, legal fiction of right to presume, irrespective of the law or the facts, implied contracts, constructive trusts, and other entirely different entities can be created using the name of the bona fide, legally and grammatically correct name of the corporation by corrupting that name into all capital letters format or by abbreviating names within the complete proper name. The corporation exists in law but has arbitrarily been assigned a different name. No such corporation nor any valid law can be created under the law of necessity, in other words, under no law. Likewise, the arbitrary use of the legal fiction artifice of right of presumption over unwary, uninformed, and usually blindly trusting people can be legitimately exercised under no law. Maxims of law describing necessity include: necessity has no law. Cloud 18 and 15. In time of war, laws are silenced. Cicero. Non-existent law equal no law basis upon which anything can be created, be made to transpire, or upon which allegiance and obedience can be legitimately demanded. Acting under the law of necessity, in other words, lawlessness, allows complete and total right of everyone to disregard any and all alleged assertions of any lawful, verifiable, and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such non-law is self-confessing to be a naked criminal aggressor and con man who has forfeited all credibility and right to demand allegiance, obedience, or compliance with any jurisdiction he might assert. If you, as a real being, are in real law and it is impossible for an attorney or judge to recognize or access it, you are not subject to their jurisdiction and cannot be made subject to their jurisdiction by them. The crucial issue is then how to notice them of your position and standing so that they leave you alone. As mentioned above, an artificial person corporation created under de jure law with the person's identifying name appearing as prescribed by law and in accordance with the rules of English grammar is a legal fact. A corrupted alter ego version of that name manufactured under the legal fiction of right of presumption will have credibility only as long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it, legal or lawful. It is crucial to define the difference between legal and lawful. The generic constitution references genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meanings? The following is quoted from a Dictionary of Law, 1893. Lawful, in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful property implies a thing conformable to or enjoined by law. Legal, a thing in the form or after the manner of law or binding by law. A writ or warrant issuing from any court under color of law is a legal process, however defective. See legal. Legal, Latin, legalis, pertaining to the understanding, the exposition, the administration, the science, and the practice of law, as the legal profession, legal advice, legal blanks, newspaper, implied or imputed in law, opposed to actual. Legal looks more to the letter, form, appearance, and lawful to the spirit, substance, contents, of law. Legal is more appropriate for conformity to positive rules of law. Lawful for accord with ethical principle. Legal imports rather that the forms, appearances of law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed. Lawful that the right is actful in substance, that moral quality is secured. Legal is the antithesis of equitable and the equivalent of constructive. Abbott's Law Dictionary. Legal matters administrate, conform to, and follow rules. They are equitable in nature and are implied, presumed rather than actual, expressed. A legal process can be defective in law. This accords with the previous discussions of legal fictions and color of law. To be legal, a matter does not follow the law. Instead, it conforms to and follows the rules or forms of law. This may help you to understand why the federal and state rules of civil and criminal procedure are cited in every court petition so as to conform to legal requirements of the specific juristic person's name. Example given, state of Georgia or U.S. federal government. That rule the courts. Lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the generic constitution has no bearing or authority in the present day legal courts. It is impossible for anyone in authority today to access or even take cognizance of true law, since authority is the law of necessity, 12 United States Code 95. Therefore, it would appear that the meaning of the word legal is color of law, a term which Black's Law Dictionary, 5th edition, page 241, defines as color of law, the appearance or semblance, without the substance of legal right, misuse of power, possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Executive orders rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevail instead of actual law. This takes place on a federal as well as state level. Government administrates what it has created through its own purported laws, which are not lawful but merely legal. They are arbitrary constructs existing only in law and are based on fictitiously created authority. In other words, no authority, and are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Looking at the United States Census 2000 reveals that the legal authority for this census comes from Office of Management and Budget, approval number 0607-0856. The OMB is a part of the Executive Office of the President of the United States. The U.S. Census Bureau is responsible for implementing the National Census, which is a division of the Economics and Statistics Administration of the U.S. Department of Commerce. The U.S. DOC is a department of the executive branch. Obviously, Census 2000 is authorized, carried out, controlled, enforced, and implemented by the President, aka the executive branch of the federal government, functioning as it has been since 1861 in the lawless realm of necessity, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive office of the president controls the entire nation through various departments and agencies affecting justice, communications, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more through a myriad of executive orders, proclamations, policies, and decisions. Every U.S. president since Lincoln has claimed his authority for these executive orders on Article 2, Section 2 of the United States Constitution. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states. When called into the actual service of the United States, he shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. He shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and counsels, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law on the heads of departments. In reality, the Congress is completely bypassed. Since the Senate was convened in April 1861 by Presidential Executive Order Number 2, not by lawful constitutional due process, there is no United States Congress. The current Senate is like everything colorable, color of Senate, under the direct authority of the executive office of the president. The president legally needs neither the consent nor a vote from the Senate, simply because the Senate's legal authority to meet exists only by executive order. Ambassadors, public ministers, consuls, federal judges, and all officers of the United States are appointed by and under authority of the executive office of the president. The Federal Register is an executive functionary. The first official act of ever incoming president, the first official act of every incoming president is to read powers. He must do so, or he is devoid of power to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917, and the Mandatory Act of March 9, 1933, the Banking Relief Act. In the Mandatory Act, every citizen of the United States was made an enemy of the government. In other words, the Federal Reserve, IMF, et al. Creditors in bankruptcy who have conquered the country by their great paper money banking swindle. For the past 65 years, every presidential executive order has become purported law simply by its publication in the Federal Register, which is operated by the Office of the Federal Register. In 1935, the OFR was established by the Federal Register Act. The purported authority for the OFR is found within the United States Code, Title 44, at Chapter 15, Subsection 1506, Administrative Committee of the Federal Register, Establishment, Powers, and Duties. The Administrative Committee of the Federal Register shall consist of the Archivist of the United States or acting archivist, who shall be chairman and officer of the Department of Justice, designated by the Attorney General, and the public printer or acting public printer. The Director of the Federal Register shall act as Secretary of the Committee. The committee shall prescribe, with the approval of the President, regulations for carrying out this chapter. Notice that the entire Administrative Committee of the Federal Register is comprised of officers of the federal government. Who appoints all federal officers? The President does. This act also gives the President the authority to decree all the regulations to carry out the act. By this monopoly, the executive establishes, controls, regulates, and enforces the federal government without need for any approval from the Senate. How could anyone possibly call this lawful? In 1917, President Woodrow Wilson could persuade Congress to agree with his desire to arm the United States vessels assessing hostile German waters before the United States entered World War I. So Wilson simply invoked the policy through a presidential executive order. President Franklin D. Roosevelt issued Executive Order Number 9066 in December 1941 for 100,000 Americans of Japanese descent to be rounded up and placed in concentration camps while all their property was confiscated. Is it any wonder that the Congress the president legally controls did not impeach President William Jefferson Clinton when the evidence for impeachment was overwhelming? On that note, why is it that the attorney presidents have used executive orders the most? Who but an attorney would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful, since the entirety of their authority, which is ethically and existentially specious, derives from the war powers. How debt is assumed by persons with all cap names. We now refer back to the matter of assumption as already discussed with its relationship to arbitrarily created juristic persons. Example given, State of California, John P. Jones. Since an assumption by definition implies debt, what debt is assumed by the newly created artificial person? Now that we have explored the legal executive basis of the current federal and state governments, it is time to put all this together. The government use of all caps in place of proper names is absolutely no mistake. It signifies an internal legal rule and authority. Its foundation is pure artifice, and the results have compounded into more deceit in the form of created, promulgated, instituted, administrated, and enforced rules, codes, statutes, and policy. In other words, the law appear to be but are not, never were, and never can be. Qui sentit commandum sentir debit et onus. He who enjoys the benefits also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is subject to its conditions. A privilege is subject to its condition or conditions. Bouvier's Maxim of Law, 1856. The birth certificate. Since the early 1960s, state governments themselves specially created juristic corporate persons signified by all caps names have issued birth certificates to persons with all caps names. This is not a lawful record of your physical birth, but rather the birth of the juristic all caps name. See birth in glossary. It may appear to be your true name, but since no proper name is ever written in all caps, either lawfully or grammatically, it does not identify who you are. The birth certificate is the government's self-created document of title for its new property. In other words, the deed to the juristic name, artificial person whose all caps name mirrors your true name. The birth certificate brings the new all capital letters vessel into colorable admiralty maritime law, the same way a ship is birthed. One important area to address before going any further is the governmental use of older data storage from the late 1950s until the early 1980s as a leftover from various teletype-oriented systems. Many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as the early 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps when this technology was first being used and implemented into the mainstream of communications, some legal experts saw it as a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during that same time period, and birth certificates and other documents, such as driver's licenses, were produced with typewriters, it's very doubtful that this poses much of an excuse to explain all caps usage for proper names. The only reasonable uses of the older data bank all caps storage systems would have been for addressing envelopes or certain forms in bulk, including payment checks, which the governments did frequently. Automated computer systems with daisy wheel and pen printers used prevalently in the early 1980s electronic emulated the IBM electric typewriter Courier of Helvetica fonts in both upper and lowercase letters. Shortly thereafter, the introduction of laser and inkjet printers with multiple fonts became the standard. Regarding the past 15 years, there can be no excuse that government computers will not accommodate the use of lowercase letters unless the older data is still stored in its original form, in other words, all caps, and has not been translated due to the cost of re-entry. But this does not excuse the entry of new data only, legacy data. In fact, on many government forms today, proper names are in all caps, while other areas of the same computer-produced document are in both upper and lower case. One can only conclude that now more than ever, the use of all caps in substitution for the writing of a proper name is no mistake. When a baby is born, the hospital sends the original, not a copy of the record of live birth, to the State Bureau of Vital Statistics, sometimes called the Department of Health and Rehabilitative Services. Each state is required to supply the United States with birth, death, and health statistics. The state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted all caps version of the child's true name, example given, James Wilbur Smith. Certificate, noun, Middle English, certificate, from Middle French, from Medieval Latin, certificatum, from Late Latin, neuter of certificatus, past participle of certificare, to certify, 15th century. A document evidencing ownership or debt. Merriam-Webster Dictionary, 1998. The birth certificate issued by the state is then registered with the United States Department of Commerce, the Executive Office, specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word register, as it is used within commercial or legal-based equity law, does not mean that the all caps name was merely noted in a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all caps legal person named thereon has become a surety or guarantor, a condition and obligation that is automatically and unwittingly assumed unless the presumption is effectively rebutted. In other words, notice to effect of, it ain't me. Security bond. Security. 1A, something as a mortgage or collateral that is provided to make certain the fulfillment of an obligation. Example, use his property as security for a loan. Surety. 2, evidence of indebtedness, ownership or the right to ownership. Bond. 1A, a usually formal written agreement by which a person undertakes to perform a certain act as fulfill the obligations of a contract, with the condition that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by that person or surety. One who acts as a surety. 2, an interest-bearing document giving evidence of a debt issued by a government body or corporation that is sometimes secured by a lien on property and is often designed to take care of a particular financial need. Merriam-Webster Dictionary of Law, 1996. Surety, the person who has pledged him or herself to pay back money or perform a certain action if the principal to a contract fails as collateral and as part of the original contract. Duhame's Law Dictionary. 1, a formal engagement as a pledge given for the fulfillment of an undertaking. 2, one who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a grantor, and the two terms are generally interchangeable. Merriam-Webster Dictionary of Law, 1996. Grantor, a person who pledges collateral for the contract of another, but separately as part of an independent contract with the obligee of the original contract. Duhame's Law Dictionary. It is not difficult to see that a state-created birth certificate with an all-caps name is a document evidencing debt the moment it is issued. Once a state has registered a birth document with the U.S. Department of Commerce, the department notifies the Treasury Department, who takes out a loan from the Federal Reserve. The Treasury uses the loan to purchase a bond. The Fed holds a purchase money security interest in the bond. See glossary. From the Department of Commerce, who invests the sale proceeds in the stock or bond market. The Treasury Department then issues Treasury securities in the form of Treasury bonds, notes, and bills, using the bonds as surety for the new securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate. This also means that the bankrupt corporate U.S. can guarantee to the purchasers of their securities the lifetime labor and tax revenues of every citizen of the United States, American, with the birth certificate as collateral for payment. This device is initiated simply by converting the lawful true name of the newborn into a legal juristic name of a person. Duplicate, re, Bosinia, pars, principium. The principal part of everything is in the beginning. Well done is half done. Legally, you are considered a slave or indentured servant to the various federal, state, and local governments via your state-issued, state-created birth certificate in the name of your all-caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when one voluntarily obtains a driver's license or a social security account number. The state even owns your personal and private life through your state-issued marriage license certificate issued in the all-caps names. You have no rights in birth, marriage, or even death. The state holds title to all legal persons. The state creates via birth certificates until the rightful owner, the holder in due course of the instrument, in other words, you, redeems it. The main problem is that mothers, parents, and then the 18-year-old man, woman have voluntarily agreed to this contrived system of plunder by remaining silent, comprising legal default latches and failing to assert our absolute rights. The maxim of law becomes crucially operative. He who fails to assert his rights has none. The legal rules and codes enforce themselves. There is no court hearing to determine if those rules are correct. Their law is self-regurgitating. Their law is self-regulating and self-supporting. Once set in motion, their laws automatically come into effect, provided the legal process has been followed. The various bankruptcies. The legal person known as the United States is bankrupt and holds no lawfully constitutionally mandated silver or gold, coin or bullion, with which to back any currency. All privately held and federally held gold coins and bullion in America was seized via executive order of April 5th, 1933, and paid to the creditor, the private Federal Reserve, under the terms of the bankruptcy. Congress, still convening strictly under executive order authority, confirmed the bankruptcy through the joint resolution to suspend the gold standard and abrogate the gold clause, June 5th, 1933, and House Joint Resolution 192, June 5th, 1933, 73rd Congress, First Session, Public Law 7310. This 1933 Public Law states, in part, every provision contained in or made with respect to any obligation purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in an amount of money of the United States measured thereby, is declared to be against public policy. The corporate U.S. declared bankruptcy a second time, whereby the Secretary of the Treasury was appointed receiver for the bankrupt U.S. in Reorganization Plan Number 26, Title 5, United States Code 903, Public Law 94564, Legislative History, page 5967. Since 1933, the only assets used by the United States to pay its debts to the Fed have been the blood, sweat, and tears of every American unfortunate to be saddled with a birth certificate and a Social Security account number. The U.S. government must conceal this fact from the American people at all costs. Their future labor and tax revenues have been legally pledged via the new all-caps juristic person's name appearing on the birth certificates. In other words, the securities used as collateral for loans of credit, belief heir to pay daily operational costs, reorganization expenses and bankruptcy, insurance policy premiums required to float the bankrupt government and interest on the ever-increasing wholly fraudulent debt. All caps legal person versus the lawful being. Just who or what is the all caps person? In other words, John Paul Jones, John P. Jones, or some other all capital letter corruption thereof. Is it the entity the government created to take the place of the real being? In other words, John Paul Jones. The lawful Christian name of birthright has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answers when the legal person is addressed, the two are recognized as being one and the same. However, if the lawful being distinguishes himself, herself, as another party than the legal person, the two are separated. A result of federal bankruptcy was the creation of the United States, which was made a part of the legal reorganization. The name of each state was also converted to its respective all caps legal person. Example given, state of Delaware. These new legal persons were then used to create more legal persons, such as corporations with all capital letters names as well. Once this was accomplished, the con really began to pick up speed. All areas of government and all alleged courts of law are de facto color of law and right institutions. The Circuit Court of Wayne County and the U.S. District Court can only recognize and deal with other legal persons. This is why your lawful name is never entered in the records. The all caps legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is constitutionally sanctioned common law venue court. Unfortunately, such jurisdictions were shelved in 1938 and is no longer available. The only courts today are statutory courts. And that will be the conclusion of the name game. Once again, people, if you come across words that you're not familiar with, you don't understand, go to your dictionary, look the words up. This is from Cracking the Code, 3rd edition. This is a book that you can find online. Do some research. Like, share, and subscribe, people. Like, share, and subscribe. Like, share, and subscribe, people. Like, share, and subscribe. Be peaceful, stay blessed, and pray to pass the Lord's test. Later.